Kevin Lemley, criminal defense lawyer here in Central Arkansas, offices in Little Rock, Cabot, and Searcy. Today I want to talk about accomplice testimony, a very important part of Arkansas law, and there's a different standard on the burden of proof for the prosecutor, and it's something we want to look at if you're accused of a crime or there were other participants. So where this is different, so let's say you're charged with a crime, it's just you. We really don't have to worry about anybody else. We don't have to be concerned what's going on with it. We just focus on you, see how we can defend it, see how we can get out of this best for you. Now, when there's other people involved, so let's say that there are 3 of you that are accused of the same crime. Now we have to be concerned about these other 2 folks, because we have to be concerned about them testifying against us, or are you going to cut a deal to go with them, or how is this going to work? So we need to understand how accomplice testimony works in Arkansas. And we do have a beautiful law in Arkansas that I absolutely love regarding accomplice testimony. And that means that you cannot be convicted based upon accomplice testimony alone. So let me repeat that. You cannot be convicted based solely upon the testimony of an accomplice. So there could have been 3 of you, you definitely did it, and the other 2 turn around and go, you were part of it, we all did it. The prosecution cannot get a conviction on that, all right? They have to have independent corroborating evidence. That independent corroborating evidence has to show 2 things. It has to show, number 1, that the crime actually happened, and it's got to put you there. If they can't get that, the case is going to get dismissed. And this is something that we need to consider if we're defending a case for you, or if you're looking at turning on someone else that was involved. And so I'm going to give you an example of a recent aggravated robbery that we got dismissed. So we'll keep it confidential. We won't say the names, won't publish the number, even though it's public. But there was an aggravated robbery. It definitely happened. And the robbery was held. There was a male that was using a gun and beat the victim pretty bad with the gun and took the $20,000 that he won at the casino. So what had happened when the guy was at the casino, there was a woman there with him that's on his arm. He thinks it's his lucky night. He's winning all this money. He's about to go back. He thinks he's going to have a great time with her. What she's doing is she's orchestrating the robbery with another female friend of hers, and then the man who actually came in and committed the robbery. So they get back, they get to Conway, the victim's sitting there with the 2 girls. Again, he thinks it's going to be his lucky night. The man shows up with a gun, and they all 4 struggle. So all 3, the 2 women and the guy, they're all part of this aggravated robbery. The victim gets beaten really bad, loses the $20,000, everybody takes off. Well, the police find the 2 women right away. They admit to everything. They admit to everything that happened, and they're trying to get the best deal that they can get. And it's real obvious where the money goes, because one of them hires the most expensive criminal defense lawyer in Little Rock. So it's very obvious. Well, they point the finger at my client, and they say that he's the one that did it. So the prosecutor is really holding our feet to the fire. The best deal they're giving us is like 15 years. I mean, it's really terrible. But as we get into the case, there's absolutely no corroborating evidence whatsoever. Because under the standard of accomplice testimony, you have to take the accomplice testimony, take it out. And then do you have anything to connect the defendant to the crime? And when we looked at everything, we said, look, there is absolutely nothing on our guy once you get out of it. There's no fingerprints in the car. There's pieces of the gun broke off. There's no fingerprints on that. There was blood in the car. None of it was his. There was no eyewitness there. There was just nothing beyond the accomplice testimony that could put him there. And so we filed the motion to dismiss. The prosecutor just dug their heels in. They just wouldn't let it go. And then the judge said, all right, prosecutor, I'm going to give you 30 more days to get something. Otherwise, I'm going to dismiss it. And so the 30 days came and went. They didn't have anything else. And sure enough, the judge dismissed it as to our guy. So he's facing life in prison. There were other charges. everything gets dismissed. Now, the two young ladies, they were getting some terrible advice from their lawyers. Because their lawyers just said, yeah, just turn around, testify against him, admit to the whole thing, you'll be great. They never bothered to look that there was no corroborating evidence. So now these two ladies, they were expecting a sweetheart deal because they were cooperating. Now they just admitted to the whole case. We got our guy dismissed, and now they're going to face the harsh penalty because the prosecutor's going to have to make it up with them. So the moral out of all this is, if we have a crime where there are other people that are accused of doing it with us, we've got to look at what the prosecution has other than the accomplice testimony, because we might be able to get the case dismissed. And if I had been representing one of the other young ladies, I would have told her not to cooperate until we saw that corroborating evidence, because she just admitted the whole case against herself. She thought she was helping, but she was only hurting. That's how accomplice testimony works in Arkansas.